This PowerPoint is on Chapter 12, and it is going to go over legal and ethical considerations with physical therapy documentation. Our objectives for this chapter in this PowerPoint are to describe federal legislation related to privacy and confidentiality, differentiate between the privacy rule and the security rule, compare ethical and legal responsibilities for maintaining confidentiality, define fraud and abuse, explain the purpose of risk management, realize the importance of informed consent, give reasons for filing an incident report, and outline different agencies' responsibilities in establishing rules for documentation. So this PowerPoint is going to go over patient privacy and confidentiality, fraud and abuse, risk management, and establishing documentation requirements. And some of this information we have already been over in previous quarters, privacy, HIPAA, that type of thing. So I'm going to go over them fairly fast when it is something we have been exposed to before. So patient privacy and confidentiality has to do with the Privacy Act of 1974, the Health Insurance Portability and Accountability Act, or HIPAA, privacy and state law, privacy and computerized documentation, and privacy and ethics. So the Privacy Act of 1974, it established federal guidelines to keep healthcare agencies or providers from releasing or disclosing medical information to any person without first obtaining written consent from the patient. This gave patients a right to obtain a copy of his or her records, and any failure to comply could result in civil action against the provider. So we already know this. We need to maintain and respect privacy and confidentiality of all patient-related information. You don't leave charts in open areas. Do not dictate in open areas. Keep the charts in a locked and secured location. And then when we're talking about electronic medical records or electronic health recording, there's some rules that go along with that as well. So the HIPAA Act was established in 1996. This required standards for performing electronic healthcare transactions to maintain privacy, and the privacy rule became effective in 2001. So the HIPAA privacy rule, healthcare providers, so us, physical therapist assistants, are subject to the rule. Healthcare plans, healthcare clearinghouses, and anyone who transmits protected health information, or PHI, through any type of media. It can be electronic, oral, written, or through a fax. The Healthcare Clearinghouse is an entity associated with the provider or third-party payer that provides services such as billing, database management, transcription, information technology, and more. So it has access to patient information and their private information, but not directly involved in their care. So electronic media can be the internet, intranet, extranets, leased lines, dial-up lines, private networks, and then transmissions occurring through, these are old, magnetic tape disc or compact disc. I think that is probably going to be going out soon, but maybe there's old health records on those type of things. I'll be curious to see who's ever used a cassette tape, and pretty soon a CD is going to be not relevant. Anyway, the HIPAA privacy rule, what type of information is protected, the PHI, and then any individually identifiable health information, the individual's medical history, their previous, current, and future medical care, and any billing or payment information. The privacy rule requires providers to make available to patients both written and posted explanations of privacy rights, allow easier patient access to medical records, provide employee privacy training, and appoint a privacy officer. If you guys have been working in healthcare already, you've probably already done some of this stuff. With the privacy rule, providers are allowed to supply information to insurance companies and third-party payers when seeking reimbursement, and discuss information with other healthcare providers who are caring for the patient without any additional written consent. So this information, again, is on minimum necessary basis. We went over this when we went over privacy. Let's say that there's a famous person in your hospital system. If you are not part of their care and you go look up their information on the electronic system, that is considered and act against their privacy. So just something to keep in mind. The security rule, it protects a subset of protected health information, so things that are in electronic format, and we have to have certain physical and technical safeguards that have to be put in place, such as changing your passwords, privacy screens, that type of thing. So privacy and state law. Privacy rule does not replace state law or preclude states from having more restrictive legislation. So depending on what state you're in, they could be even more stringent. Privacy and computerized documentation. Computerized systems maintaining patient records must be password protected. The AMA recommends assigning different security levels to differing degrees of data sensitivity, and there must be a process for backing up and storing records. So privacy and ethics. It is the ethical responsibility is generally determined by professional associations. So we don't only respect people's privacy, but we have an ethical responsibility to our patients. And this is defined in the Standards of Ethical Conduct for the Physical Therapist Assistant, the Guide of Conduct for the PTA, and the PTA is bound by professional ethics and conduct. Conduct is outlined by our professional association, the APTA. It's our duty as PT and PTAs to be familiar with the standards and follow them in our practice setting. Documentation provides evidence of appropriate and ethical care. So remember that documentation provides evidence of appropriate and ethical care. And this includes communicating on a regular basis with your supervising PT to ensure the plan of care remains appropriate and the PTA works within the scope of practice as outlined in the State Practice Act where they are practicing. And then legal responsibilities are determined by the laws of the state that you're in and also some federal laws. So ethical resides with the professional associations, legal is by the laws of the state or federal level. So fraud and abuse, unfortunately, this is something that does happen in our profession. As you see on the slide, each year Medicare and its beneficiaries pay millions of dollars towards fraudulent claims. Fraud is a crime and punishable by law. Agencies that detect and prevent fraud are the Department of Health and Human Services, the Inspector General, the FBI, and the Department of Justice. Accurate billing corresponding with documentation can help prevent fraudulent accusations. And in class, we will get into this more exactly, some examples of fraud and abuse that have happened in the U.S. So fraud is billing an insurance company, Medicare, or other third-party payer for services that were never provided or billing for an item or service that was a higher reimbursement than the service provided. Pretty straightforward. It is a physical therapist assistant's duty to report any unethical or illegal acts, including knowledge of fraudulent billing practices. Abuse is different than fraud. Abuse is the result of an error, so it's unawareness of a proper code or coding procedures. And to avoid abusing the system, you should stay informed regarding reimbursement guidelines for insurance companies or payers that you encounter frequently. So staying up to date on what is going on is just a simple way of doing that. And the APTA has really good resources on that. Risk management, those are activities geared towards minimizing the potential risk for healthcare abusers, including therapists to, for one thing, be subject to fraud and abuse or to take part in that. Also to investigate complaints or concerns as they're brought forth, and investigation can include an examination of the patient record and available documentation. That's why we have to be careful that we are documenting what we do with them and it backs up the care that we are billing. So risk management includes two important documents: informed consent and incident reports. Informed consent, you guys have been doing this ever since your first quarter in the program. It's a process by which treating the healthcare provider discloses appropriate information to a competent patient so the patient makes a voluntary choice agreeing to or rejecting a specified treatment. So this includes describing the nature of the procedures, the risks, the benefits, the uncertainties, the reasonable alternatives, and the assessment of understanding. This also allows the patient to ask questions. So that is why informed consent is so important important and why it's a starred item, and why we really work on you guys being able to explain what you're going to do in patient language or layman's terms so the patient can understand what you are planning to do with them and they can make a decision as to if they're going to participate or not. And if the patient is not able to give informed consent, sometimes you need a substitute decision maker. An incident report, hopefully you never have to fill this out, but there's a good chance that you possibly could. So it's a document completed when there's an incident that could likely result in a lawsuit. The goal is to document errors and departures from unexpected procedures or outcomes. So for instance, a simple incident report I had to do, there's this lady who had very sensitive and fragile skin, and when I transferred her from the wheelchair to the mat table, I caused a skin care. That had me perform an incident report, and part of the incident report was to talk about how I could prevent it from happening again. So, you know, hopefully nothing major happens. Hopefully we're teaching you guys enough to be responsible and careful, but things just happen, as you saw with my example. So roles in informed consent, the physical therapist is responsible for obtaining that informed consent prior to working with the patient. You know, for the very first time, the PTA, as you work with the patient under the plan of care by the PT, and you need to be aware of the patient's previous medical history and current pathology, and again, to stay abreast of the literature describing indications and contraindications of various interventions, and you know, what has the best evidence-based practice behind it too, something else to consider. So incident report, there's 3 categories of critical incidents: adverse outcomes, procedural breakdowns, or catastrophic events. Hopefully none of you are ever part of a catastrophic event. It's filed with the risk management department, and it's not a part of the patient's medical record, it's part of the facility's records. All right, who establishes documentation requirements? Federal agencies, CMS, Medicare, Medicaid, JCAHO, State Practice Acts, and the APTA. You guys already know that. Legal issues, I just want you guys to know that that could be a part of your career, and any professional interaction with the public brings challenges that may result in litigation. It's just a part of our job. PTA's responsibilities, if you ever had to testify in a legal setting, is your documentation could be used in legal circumstances. Like we said earlier, if it's not documented, it didn't happen. And if you ever do have to testify in court, you will have to likely refer to your documentation because you're not going to remember all of the information about that patient. You're going to have to keep it simple and don't offer more information if needed if you ever have to do that. And that is the end of this chapter. Thanks.